I pray for listing of one matter for motion tomorrow. There's been filed yesterday.
May I please your lordship, with the consent of other side lordship, I beg to mention item number 7. Here I have not received the instruction flow. Item number 7.
Who's for the petitioner?
It was not aware panel as yet.
Huh?
It is not aware panel. The second is not aware panel till yet.
So there is stay, no?
Is similar.
Right, Mr. S.S. Roy, Learned Counsel appearing for the
Respondents.
respondents. Prays for time on the ground that he has not received any instruction. That is allowed. This,
After 3 weeks,
this is the matter after 3 weeks to enable the respondents to file their affidavit. Interim order to continue to the next week.
obliges.
Lordship, I wish to mention an item for listing matters. It's filed today matters. It's filed today matters. I have the listing number.
When do you want it?
Tomorrow matters. It's a tender matter matters. Obligation.
Maybe the lordship. Lordship, I pray for listing of matter next week. It's for others.
Do it.
It should be this. The Lordship's permission, I think this is a writ petition 2260 of 2024. It was last listed in the month of April. There are some subsequent events which has happened. I want requesting it for listing on Friday if it is not inconvenience to your Lordships. I'm extremely grateful.
Lordship, I beg to mention for listing on tomorrow for goodwill, lordship.
May I please your lordship? Your lordship, with the consent from the other side, I beg to mention item number 11.
11, yes.
Your lordship, my senior is out of station, your lordship. The matter may be listed after 1 week.
Who's the other side?
Okay, I may be.
You're for the petitioner.
Yes, Lord.
Okay, you're for whom?
I'm for the respondent,
Who's your senior?
Mr. S.P. Roy.
Mr. Right, a genuine prayer has been made on behalf of Mr. S.P. Roy, Learned Counsel for the respondent, which is not objected to by Miss
F. Begum.
F. Begum, appearing on behalf of
F. Bunny. The standing counsel of FPDCM.
Actually, you are both for respondent.
Yes, your lordship.
Actually, this is by the APDCL. There is, who did you say? The APDCL Council, what is the name?
F. Bunny. Clerk.
His name is not here.
Yeah.
Not in the cause list. Sorry, madam, S. Manik's name is not in the cause list.
He is newly appointed.
Appearing on behalf of, this is on behalf of the Standing Council APDCL. This is that. Don't give any name.
Lordship, interim is there.
Interim order to continue till the next day. So this is the matter after 3 weeks.
I don't want to force same subject that panchayat order. What can you take up 4 item 4 first?
17 also, your Lordship.
I think 4.
Anyway, either take up 4 or it's the same thing.
Appearance, so I can assist your lordship in better.
Okay.
In this case, your lordship already aware of the matter, my lord. Initially, NIT floated. Then comparative state already finalized. Comparative state in May. Madam, thereafter, my lord, they come up with a cabinet decision that it has been cancelled and a new, my lord, tender will be floated. And in the interim, that is also extension is given to someone. Both of that they cannot do, madam. Already they executed, idea and thereafter, they are saying that, madam, that is it will be given extension to.
Yes, when is the new NIT going to be floated?
Your Lordship, on the last occasion, we are actually being instruction, Your Lordship. This is the instruction, Your Lordship. Yes, sir.
That is neither here nor there.
Your Lordship, modified NIT has been prepared, Your Lordship.
Okay, that's all right. That is not the question. That is not the answer to the question posed by this court.
Your Lordship, on the last occasion, we are asked in what stage the matter is.
It is like saying that model, when is he going to start modeling? He said, oh, he's a very handsome model. How does it mean? It is not answering the question. You see, the question is this. Basically, NITs, the term has expired, earlier term. Now, I think they have a problem with the extension of the term of the
Yes.
previous settlement holder.
Both, my lord.
No, you have a problem with that, but that I don't think you've got a case because the reasoning is, I don't think is anything wrong. It's for the benefit of the public.
But that cannot be get after everything over, my lord.
Then if it cannot be done, then it should not be done.
It should not have
You
been
see,
done.
this is for the general public.
Anyway, my lord, two parts we have.
There are two parts. Only thing is that more than that part is that the issue of this person, the previous settlement holder carrying on the operation of the settlement. They are more aggrieved with that. You see, so what to do now?
Your lordship.
Yeah, I think you terminate their settlement,
Your lordship.
extension of their settlement period.
Your lordship, the otherwise also the state government is empowered under section 122 of the act.
Okay, show me that.
But 122.
Of which act?
Assam Panchayat Act 1994. Because it's a policy decision, your lordship. It is a policy decision,
122.
122, your lordship. Section 122.
Yes.
Direction from government. Section 122, subsection 1. Notwithstanding anything contained in this act, it shall be lawful for the government to issue directions to any panchayat in matters relating to state and national policies, and such directions shall be binding on the panchayat. So, your lordship, it is a policy decision, your lordship. So, state government is empowered. And a direction given on the, under this provision, your lordship, it is binding on the PRI, your lordship. And from the-
Wait a minute, let us see this 29(6). What is the order? Pursuant to the direction, decisions taken, governor refused to cancel the this is not a direction to the panchayat. You are in the impugn notification. Where is it?
your lordship may
Because so it says that existing license may be given extension.
your lordship,
Under,
it
no,
pass-
where is the provision for giving extension? Just show me.
your lordship, since this is the interim arrangement, your lordship, just to give an effect.
Mr.
to the
Council,
policy,
I
your
know
lordship,
that. It's an interim arrangement.
arrangement. And your lordship, from
But
the,
then you see, interim arrangement has to be as per law. It cannot be as the whims and fancies of whoever the powers that be. It has to be as per law.
your lordship, kindly see from the instruction we had received, because from the cabinet memorandum, your lordship may kindly see the item number 17, your lordship, 3613. Read petition number 3613, public 2024, your lordship. Here, your lordship, page number 34, we have annexed it. Annexure 4, your lordship.
Where?
Answer.
Where?
Your lordship. Ensuring fair prices for markets and bazaars.
That is all right. That is already there in the impugn
Your
notification
lordship,
also.
the PNRD, your lordship, in the cabinet decision, it is decided that PNRD will modify the modalities, your lordship. Because may kindly see, your lordship, PNRD department will decide the modalities for selection of
Mr.
highest bidder
Counsel,
in case of,
I'm not on that. It's not a question of modifying the modalities. You modify from here till kingdom come, that's all right.
your lordship.
The issue is whether you can extend the settlement period of an erstwhile settlement holder in violation of the Panchayat Act.
Your lordship, there's.
Show me the period of settlement period as per the Panchayat
Yes,
Act.
yes, under 105, your lordship.
Ah,
This is for one panchayat year.
one Panchayat, and
One
when does it,
Panchayat, yes.
when does it end as per 105?
But your lordship,
1055, your lordship can see, 1055.
now in this situation, your lordship, we will have to read 105 along with 122, your lordship.
Mr. Council, if you want to read 105 with 122, please read 122, 1 with 122, 2. Then you go into the other. You see, it has 122, 1 has to be read in conjunction with 122, 2. You cannot read as you want.
Your lordship, it is going to be, they are going to be issued note. NIT also shortly
You see,
also
you
on
see,
the
you see,
appropriate
you
period.
see, please, you see, it's not like a fish market that
Yes.
you say everything you want to say
Yes.
and I say anything I want to say. You have got to make your arguments as per the statute. Now, 122(1) speaks of, 122 speaks of direction to the panchayat that can be given by the government.
Yes.
Now, 122(1) has to be read in conjunction with 122(2). Now, what does 122(2) say?
Your lordship, there are huge numbers of markets, your lordship. As per 105, if the settlement could not be given within the existing financial year to the new lessee, your lordship, the concerned PRI have to run the market directly. But
Let them run the market.
your lordship,
You run the market.
problem is that-
1055.
practical problem is that is the manpower.
I know. But
If
what,
it is only one
but then,
market.
but then
that's-
just because you are lacking in manpower, does it mean that you can violate the law?
Your lordship, while administrative decision is taken, some freeness in the joints is with.
Mr. Council, that is all right. Those are contract matters where there is no statutory law. Out here, you have your Assam Panchayat Act. This is an act. Can you say that the act says this, but we can do this and that? We can make, making like rotis. The maida or the atta, you want to make it this shape and that shape. Can you do that? What are you talking?
Your
You're a
lordship,
council. This is a statutory law.
your lordship, another provision I would like to refer, your lordship. Section 132, your lordship, may kindly say.
Yes.
Removal of difficulties, your lordship. 132. If any difficulty arises
Correct.
in giving effect to the provisions of this act,
Yeah.
the government may take such necessary action so long as these are not repugnant to the
Repugnant.
main objectives and provisions of this act.
If they are not repugnant to the provisions of this act.
Your lordship, we will have to read the three provisions together, your lordship.
You see, it says as long as. Please remember, it is conditional. It says as long as these are not repugnant to the main objectives and the provisions of the act. As long as it is not repugnant to the provisions, you can do anything you like. That's what it says. You see, that's why I have been asking you the last day. When are you going to come out with a new NIP? If you come out tomorrow, the after is good. But then you,
Shortly, your lordship.
I mean, shortly means what? It's like you asking for, I'll be submitting my affidavit in a position within 2 weeks. I need 3 weeks. You take years. It's like that.
Your lordship fixed it time frame. Your
I
lordship.
cannot fix it. It's you who have to do it. You do it.
Otherwise also, if we cannot run the markets directly, the PR as I am saying, your lordship, then it will again loss of revenue.
Correct? Maybe.
And the PRIs will suffer in the. long
What
run.
you can do is, you see, what you can do is, you can float a tender for temporary settlement for the time being.
Yes.
Can float thing for a temporary settlement of the market till you come out with a proper tender NIT. Or we can say that the NIT which has been floated now, then let it be settled only for the purpose of temporary settlement till a proper NIT is issued.
It will again go
Or
against
it's again
the
a problem.
policy decision. your
That is
lordship.
the, that
The
is the,
public interest that decision is taken.
then, that is the problem.
The AD action also sometimes. The open action.
That is why actually, if we stop everything, then y'all will work very fast. Within 1 week, I think everything will be clear. Neither will they be allowed to, because the objective is very clear. The objective of cancelling the tenders seems to be very clear.
Yes,
It is for the general public.
yes,
It's not only for those tenderers. Tenderers are just the collectors.
yes. They
Yeah,
are,
the-
they are on
They
their
are,
private interest.
they are apparently, rightly or wrongly, I do not know. They are collecting higher tolls,
Yes,
which affects the farmers.
yes,
And ultimately it affects the consumers because we have got to pay higher amount for the vegetables.
Yes.
So for them, we are not going to allow this, the thing. Only thing is that they are correct in a way that we don't know when you are going to complete the process. You have to take it seriously. You see, this is of 29/6. And this order that was passed by this court was when? Was on
on 24.
24/7.
24/7.
Today is
30.
30.
30.
So already 6 days have gone.
Yes.
And
It
the,
may take another 1 week,
maybe,
not more than that.
but then you stop this, we do not know
Mm.
whether it will take, probably it will take 1 week, maybe 2 days also. But it might take, it might take 1 month or so. Because, no, because you
The
see,
impression,
it is
we have
not
to
only, it is not only the tender.
yes,
Once tender is made, that has to be approved. Approved, then it will go to the district. Then those panchayats will have to publish it. And the entire, then making the settlement, all that will take another 1 month or so. So all in all, it might take another 2-3 months. That is the problem.
lordship, my contention is the petitioner is, yes, there is a statutory provision, but they are on private interest.
Correct, correct. No,
Department
no. That way,
The
public
interest.
interest has
They
to
have
outweigh individual interest. That is there. That is the law.
Yes,
The law is very clear. Or, and maybe you can yes, what to do, Mr.
1055 your lost condition. Very clear, my lord.
I have already
Yes.
mentioned your lordship in my submission, your lordship.
Yes,
Yes.
That is Anshuli Panchayat will be entrusted for any,
Failure to settle any hurt for want of,
Assam Panchayat Act 1994.
yes.
yes.
Huh?
So,
It is failure to settle.
yes. for want of adequate value, the Anchalik Panchayat has may be decided by Jila Parishad, may be entrusted to the direct management of such art by the Anchalik. There's very clear provision is there.
They may have
Yeah,
daily,
they can do it by,
but daily.
they can do by daily auction, by open auction. Temporary settlement,
So the Anchalik Panchayat can look after it.
yes, yes, they can do it.
You all look after it in the
Clear
meantime.
provision, my dear.
In how?
Your Lordship, the problem is that in one panchayat, there is only one tax collector, Your Lordship. In a market, how he will collect?
So they can go for
So-
daily kind of that, they can go
That is
for.
the problem.
Huh?
Daily
You
arrangement.
think,
If it is only one market, then Anchalik Panchayat can manage.
Oh, they are not direct.
But there are so many markets under the one Anchalik Panchayat, Your Lordship. That is the problem.
you think of some manner, you sit down and think, maybe you appoint somebody to act on your behalf.
Temporary settlement or can be.
Because the earlier, because there is no provision for extension of
Yes,
earlier settlement holder.
yes, sir. It is admitted. It is
Yeah.
admitted. Law is clear, yes.
Then
But
if,
since it's a policy decision in the interest of public, it has been
no,
taken.
no, that part I'm not interfering.
Yes, yes.
This court is not interfering on that part. The court is only because they are also having a point. Because you are not sure when the new NIT will come. You see, your instruction is not neither here nor there. So they are worried that in the meantime, their rivals will continue making money. They also want a share of it.
That is, they want money, that's why.
Nothing, everybody wants money. So y'all can think, y'all can devise a plan. I won't say how, there are many ways.
Yes.
So there are many ways of doing things, you know. You can make aloo fry, you can make aloo gobi, you can make tikki. There are many ways of doing things. So you think of how to do it without violating the provisions of the law. That's all. Okay. Have you made those persons parties? Those settlement holders?
No, they're already over, my lord.
Maybe, but then they've
After
been,
over, they have no right. Why?
been given a fresh
They
lease of
cannot
life.
come and agitate their right will be over.
No, Your Lordship.
And action has not been granted yet,
Not been granted yet.
not beyond. They have taken a decision to grant,
No,
not
Your
yet not
Lordship.
granted. Had it been granted, we could have made party also.
Your Lordship.
Huh?
Wording is, my lord, that is,
Your Lordship, the 3663 petition. They
Yes.
like some documents, Your Lordship.
Yes. Oh, you'll be allowed to be lessee
Yes, Your Lordship.
for a
The
period of
TRI
1
says-
month
Yes, sir.
with effect from 1/7/2024.
Subsequent to the government notification, Your Lordship, the TRI said,
So probably they've given 1 month extension to everybody.
Yes.
So no more extension.
yes.
Today is the 30th, so no more
Already
extension.
That will do.
Okay. Then what to do with this case?
but here it is written until new tenders are finalized.
Correct,
Ah,
that is what we.
That is your lordship, is right,
Yes.
this is the point.
But this will- this will-
So we'll keep it pending, the cases
Yes,
heard. Yes, sir. I think we'll tag all these cases together.
yes, together, Your Lordship.
This item 1 to 4 and 17.
They will have to implement the,
No, we cannot, the party, what we can imprint, madam. Nobody, no extension is given to anybody.
No, you see, no, that,
No, in my case, madam.
no, it's for a period of 1 month only.
yes, Your Lordship.
So 1 month ends today. It ends tomorrow. It ends today, in fact, tomorrow, in fact. So beyond this 1 month, no more extension should be given.
Your Lordship, the if it is the no extension is given, Your Lordship, then,
Huh? No more extension should be given. We'll make it clear.
Then there is nothing left to challenge, Your Lordship. Purpose is that extension should not be given and settlement is done immediately.
Correct, correct.
That is their game.
So we can, in another way,
Put it as
we
possible.
can dispose of the writ petition, saying that the new NIT should be issued within a period of 10 days or 2 weeks or something like that.
That cannot be done, how can your lordship might not direct them to float it, my lord?
That is there.
Yes,
No, but then otherwise,
yes, sir.
nothing survives now. No, so you want to have a hearing on whether this,
So I want a hearing, madam, because your lordship, it is the first question was not, we cannot, my lord, take it lightly, first one. You have floated tender in May. Your government has no knowledge that they are.
then, you see, at the end of the day, when you look at the reasons for this 29/6 to 2024.
What is the reason, my lord? Once you come to know that we have already decided, we have already given
No,
some
no.
amount,
No,
then some interested person could not get it.
No.
So have the.
no, no.
What is the reason?
Please read
Yes.
the second paragraph.
Yes, page 43 in my case.
Yes, please read. Second paragraph.
Second, as complaints have been received at various level, that the small traders, vendors and other sellers in the huts and bazaar are often exploited by the bidder who could exorbit high bid prices to get the lead. The Governor of Assam is further pleased to make provision that no settlement shall be made with bidders who quote more than 10% of average settlement of the last 3 years of this so and so. Accordingly, the new NIT will include the condition and such modifies into its so and so. It may come from next year, my lord. Why you have floated a tender, my lord.
If you are going to be so adamant, okay, I can change my mind, no problem.
Huh? Yeah. Question, my lord.
This is for the benefit of the
Two things,
public, not for you. You see, you are only wanting to make money. You are only wanting to operate the market.
Everybody needs money.
Then-
Worship needs
then
money,
you are
I
going
need
to-
money, everybody needs money, my lord.
No,
For
sorry.
legal purpose.
For you and for they and me, we want
Yes.
to buy the vegetable, we
Yeah.
want to buy aloo at 5 rupees a kg, not at 30 rupees a kg.
So,
So if you want it that way, I can give the reasons why this,
that reason may be looked into, my lord, your lordship may examine that part. Their part, the question of law, my lord. But so far second part is concerned, I think your lordship, we have a case part. First part, your lordship may examine the first part, my lord.
But what is the first
About
part?
the law. Second part, my lord, extension. The 1055 is very much clear. They can for daily auction, open auction, temporary settlement. They can do. So many options are there. It is not necessary until Panchayat itself is to conduct or run the market. It's not necessary. They can go.
Anyway, then you file an affidavit in the meantime. That is okay. Right. Yeah, right, which is your case? WPC?
Pardon?
4.
I am item 4, my lord, application number.
Okay, right. Heard Mr. H.R.A.
Yes, sir.
Chowdhury, Leonard Senior Counsel for the
Fine, fine,
petition.
fine, fine.
Who submits that the impugn notification dated 29/6/2024, wherein the ongoing process for settlement of huts/guts/fisheries/pounds, etc. for the year 2024-25, for which NITs for which the floated NITs have been cancelled, should be set aside. He submits that while the impugned notification dated 29/6/2024, the earlier settlement holders of the huts/guts/fisheries/pounds, etc. have been given extensions for operating have been given extensions for operating the huts, guts, etc. till a new modified NIT is introduced by the government. Next paragraph. then you take this paragraph, the petitions council submits, the second paragraph. Second and third paragraph, what is it? Yes, sir. Next paragraph, the petitioners council further submits that in terms of section 105 of the Assam Panchayat Act 1994. The settlement of hut, gut fishery, etc. cannot be for more than 1 year. Which has to end on 30th June 2020, 30th June of a particular year. Now, which is from 1st July to 30th June of the next year. He submits that the extension of the settlement period of an earlier settlement holder beyond 1 year is violative of the law. Next paragraph. Mr.
K. Kumar, Your Lordship.
K. Kowar, the learned counsel for the PNRD department.
Should be additional AG, Your Lordship.
For
He's additional.
Acha,
Yes.
the additional AG appearing for whom?
All the official respondents.
Appearing for all the respondents.
Official respondents.
They are what?
How official the sovereign? Because what? All are official, my lord.
What? 4 and 5 are what?
Yes, sir, I am appearing, Your Lordship.
Then you appear for all the respondents.
Yes, sir.
Appearing for all the respondents. Submits that in terms of, you want me to quote this section 122?
Yes, sir.
You sure? I don't think it's correct. You want to quote?
Yes, sir.
Okay.
Your Lordship, when we go to Your Lordship, just mention.
Okay. Submits that that there is no infirmity with the notification dated 29/6/2024. Impugn notification dated 29/6/2024. Inasmuch as a modification of the NITs is required as complaints have been received that due to the bidders who quote exorbitantly high prices for settlement of the huts, fisheries, ponds, etc. are exploiting small traders, vendors and other sellers to cover the cost of the exorbitantly high bid prices, which ultimately affects the general public who go to these huts, fisheries, etc. for buying their everyday needs. The additional AG submits that the new modified NITs will be approved.
This has been prepared, Your Lordship.
Huh?
It has been prepared, Your Lordship, pending approval of the highest authority.
Will be approved within a week. And the huts, fisheries, ponds, etc. will be settled on the basis of the modified NITs, which should be in the interest of the general public. Next. Next, on considering the fact that the reasons given in the impugn notification dated 29/6/2024 is for the interests of the general public, and for the general public, some more time is required to be given to the state respondent to bring out the modified NITs. Thereafter, the question of whether the modified NITs thereafter the question raised by the petitioner with regard to whether the present NITs which have been cancelled should be restored can be taken into account, can be decided. Full stop. Further, it is settled law that public interest will always outweigh individual interests. Full stop. Next. In terms of, perusal of the Assam Panchayat Act 1994 nowhere indicates that a settlement period can be extended by the state. Correct? By the state. Full stop.
In 1917, section.
Yeah, who are you?
In 1917,
Here in 17.
yes.
Acha.
Correspondent number 4. In section.
You're a
120
private?
Yes. Yes.
You're a private respondent in one.
1917. So, section 122 provides power to the government to issue instructions.
Okay.
So that cannot be taken absolutely without.
No, I will not go into that. According to me, right now, I do not find. We'll see that at the time of hearing. Right. What have I said? By the state. Full stop. In the present case, the settlement of the what is it in the present case, the settlement of the
Oh, but now. In my
the
case,
settlement of the Krishna Daily
yes,
Weekly.
Tamul Pan and Sukan Supari market has been extended in
yes.
favor of one Mr. Abdul Jalil for a period of 1 month with effect from 1/7/24. On considering the fact, on considering the fact that this court does not find any provision for extending a regular settlement beyond the period provided, beyond the period of settlement provided in section 105,
155.
1051 of the Assam Panchayat Act 1994. The state respondents are directed not to extend the period of settlement of the said market any further. The said market should be run by the
Your Lordship,
concerned Anchalik Panchayat.
In terms of section 1055.
Your Lordship, the liberty may be given to the TRIs to formulate the device, Your Lordship.
You see, you can always formulate your own device. I'm keeping that silent. I'm just saying, you can think of it. I cannot spoon feed you. Otherwise, you say the High Court allowed us to do this.
Definitely, Doctor.
In terms of section 105(5) of the Assam Panchayat Act 1990. When list the matter on? When can you said within 1 week it will be done.
After 2 weeks, you know.
This is the matter, today's what, today's 14th, 13th, this is the matter on 13th. By which date the respondent shall file the affidavit. Still is not fine.
Only two markets,
Oh, I have mentioned.
your lordship. One is Krishnai weekly market, other is
Huh?
Tamil. This is in the synopsis, in first, second line, your lord, two markets.
I have mentioned two markets. One is that Supari market and one is Sukan market.
One
One is the daily market and one is the.
is a
Weekly market,
weekly market, other is a daily Tamil pan.
synopsis second.
One is the
The
Christian
synopsis-
daily Tamil Pan and
Yes.
Sukan Supari market.
Yes.
I think
First-
that is,
First one is Krishnai weekly market.
Krishna
Second-
weekly
second-
market.
Krishnai weekly market and Krishnai daily Tamil pan. and
Okay, one is Krishna weekly market and second one is Krishna daily Tamil Pan and dry Supari market.
Name is also my published to us.
Then who has got private respondents? Only you.
No, I don't, I am not.
You don't
what
have,
happens
no,
by
here
this
they have got. How you feel? Mr. R. Ali, R. Ali, give me, which item? Item?
70.
70. Acha, in all the others, only, huh?
I have no private respondent.
In item one,
One,
your name is,
MK Hussain.
you have taken the names, all. Okay, so same order.
Market is
1 to 4 will be same.
Market is different only.
Market will find in the synopsis.
Synopsis.
In the synopsis, the market will be.
Market and Anshalik concept.
Market, okay. 17 is fine.
70 only.
Okay, out here, same thing. Heard, so, Mr. R. Ali for the petitioner. And, Mr. So, for the additional AG. And Mr. M.U. Mahmood appears for the respondent number 4.
Oh.
Yes.
Your lordship, the next date may kindly be fixed on 19, your lordship. 19 August, your lordship.
You should have been there. No.
Don't you say, your lordship?
They're saying, he's saying 19th,
On 19, your lordship.
19.
On 19 August. On 19 August. Next date.
Any objection? Any problem? No problem. No, 19. Yeah, 19. Okay, then out here you write one thing, huh? Mr. M.U. Mahmood, the learned counsel for the respondent number 4. You have been given extension. Where is the extension order?
It is 37, madam. 1/7/2024, and it is given until further order, till final setting.
No, this cannot be.
Hello?
You cannot run this market beyond this 1 month.
I will file affidavit, I will clear my, but one important question, my lord. My learned friend is here. When there is a cabinet decision and there is notification issued pursuant to cabinet decision, whether the single bench of the Honorable High Court has power to interfere with that or not, that is a question.
No, the question,
on that.
the question is this. Whether a cabinet decision can overrule an act.
That is a separate question.
No, that is the question.
This is the law.
I am only whether and you see, whether the cabinet decision is and whether the cabinet decision can it give extension of a settlement holder when 1051 says, I'll read it for you. 1051, it says, all huts within the territorial jurisdiction of Anchalik Panchayat shall be settled in the manner prescribed for a period coinciding with and not exceeding.
My lord, that is correct.
Then-
But lordship, that
So-
section should not be read isolatedly.
No, correct.
That
Cannot,
should be read in
cannot.
section 122.
No, maybe, but 122 does not speak of giving settlement beyond the settlement period. That is a law laid down by this court in various orders, judgments, which has not been challenged in appeal.
However, my lord, we will file affidavit and we will clarify our position.
No, no, that is, I have got the judgments also. I have got, I think, yes.
You lordship's order, my lord.
My orders, there are also some other orders are
And
there.
other orders, my lord.
Other, it's all there. The law is clear. So cabinet
Seven.
cannot override the law. Cabinet decision cannot override the. Same thing as parliament when they did that NJAC. Parliament had to override the law, I think.
My lord, may I satisfy your lordship by this point that cabinet has not taken the decision on a year. Cabinet has got the power and from section 122.
Let them
That
amend
is,
the,
that is the foundation. On that, right?
you challenge these orders.
No, we are not. That means we will submit, my lord, and the next day we will submit. Because today is only motion day. If your lordship fix the matter for admission, on that we will submit definitely, and it is my duty to satisfy your lordship. And what my learned friend has submitted, I don't know whether they are, but we have also got decisions.
There's no decision, I know. If you want, we'll take it up day after tomorrow. You bring your decisions.
On the matter.
Only on the question of law, not on the question of facts. There's nothing here.
Yes.
There's only a question of, you bring the
That-
judgment day after tomorrow.
The day after not 19, everything, because I said
No.
it will be,
Why 19? Day after tomorrow is
because
good enough.
other matters you have lordship has fixed on 19.
No, yours is slightly different because you are here. Because you have got citations, which I want to read also.
No, that citation, the citation is also applicable in 1, 2, 3, and 4 also. So at the same day maybe fixed.
No
somebody like-
need. We will do yours separately. Yes. There are various judgments by this court in 2000 also. 2009 also.
2009 of. Every year petition filed for extension, every petition discussed.
2024 also. So that is why there, I don't think you have any citations in your favor.
Let me try at least.
When, day after tomorrow,
No, next week, well, I have to sub-
next week.
next week.
Okay, let him take next week.
But in the meantime, impugn order may kindly be stayed.
Now,
If
we
they
have-
can
We
satisfy.
have already taken possession and it is running.
What
No.
position is not.
The law is very clear, Mr. Counsel. The law is very clear. It's here. 2003 GLT 528, 2009 2 GLT 553. This court in 2000 has held. This court has further held that any settlement made beyond the panchayat financially has to be made by inviting tenders, as expressly provided in section 106. Right. Right, Mr. R. Ali, Leonard Counsel for the petitioner. Mr. Pawar, additional AG appears for the state. Respondents number 1 to 3. Mr. M.U. Mahmood, Leonard Counsel appears for the respondent number 4. The grievance of the petitioner is that the respondents number 2 and 3. Now, the respondent number 2 issued tender notice dated 1/6/2024 under the Assam Panchayat Act 1994, hereinafter referred to as the Act, inviting tenders for settlement of huts, etc. for the year 2024-25, with effect from 1/7/24 to 30/06/2025. The last date for submission of tender was fixed on 21/6/2024. The petitioner and 7 others submitted the bid document. The tenders were opened on 21/6/2024. And after examining the comparative statement, the petitioner's bid was found to be the highest. The committee forwarded the tender documents along with the comparative statement to the Barpeta Zilla Parishad for approval and to issue settlement order. However, by notification dated 29/6/2024, issued by the Principal Secretary to the Government of Assam, PNRD Department, all the ongoing process for settlement of huts/guts/fisheries/pounds, etc. for the year 2024-2025 were cancelled. And it was directed that until new tenders were finalized, the existing settlement holders may be given extension at the settlement value fixed for the year 2023-2024. The petitioner's counsel submits that there is no provision for extension of a settlement in terms of the Act. In this regard, he has relied upon the judgments of this court, which has attained finality as on date. They are Koheshwar Bharali versus State of Assam and others, 2003 GLP 528. Ali Akbar versus State of Assam and others, 2009 2 GLT 553, etc. Next paragraph. The
One submission.
petitioner's counsel submits that the impute notification dated 29/6/24 should be set aside, and the selection of the settlement holder should be finalized in terms of the tender notice dated 1/6/2024. Mr. For the learned censor, same thing, what he had said in the earlier. Same thing there. Then Mr. M.U. Mahmood, learned counsel for the respondent number 4, submits that in terms of section 122 of the Act, a temporary extension of the settlement period beyond the settlement period can be made by the government/panchayat.
Order may be issued by the government, that is there.
Naturally, it's a panchayat/government/panchayat, that's all. Anyway, that is against the law laid down by this court. Law laid down by the single bench of
That
this.
I am submitting, my lord. This is the citation of 2009 and district cabinet decision only just few days back.
Maybe,
So
maybe,
in between, many things have happened.
maybe.
So finality.
The law, the Act has not changed. The Act has not changed. Cabinet must have changed 5-6 times, but the Act has not changed.
Section 122 is also part of Act.
Correct. And when a coordinate bench, earlier bench, has said that there cannot be extension, who am I? I
Your
think-
lordship has also
Who has-
decided.
Now let me.
No, that's there also.
Let
My
me-
order is
let me
also
take
there. I
some
know.
time for your, to satisfy your lordship.
No, no, there's nothing to satisfy. You can go before, you see, I cannot change my view now. You can go
Balance
in
of
appeal.
convenience should be also taken.
You,
into
you go to
consideration.
the division bench and you say this judgment is wrong.
No, no, I am not on that.
You have
I
to
am not
go.
that, unless I
No.
get better judgment, how I can say?
That is why now I am stuck. I know the judgment because I have authored one of them.
No, no, so far the stay matter is concerned, that my submission is that, my lord. There should be at least three golden principle, that prima facie case, now favorable decision, balance of convenience, irreparable loss.
Nothing is
I
in
want-
your, nothing is in your favor because the law is not in your favor. Section 105 is not in your favor.
But 122 is 122.
122 is also not in your
And
favor.
policy decision of the government, my lord, there are hundreds of judgment. Policy decision of the government should not be cancelled or
Correct.
overlooked by the court
Correct.
very easily. Because
But if it is in violation of the law, then what happens?
that is why I want a hearing. But your lordship is not ready to hear.
I cannot help it.
No, no, no.
You go,
Policy decision,
you-
court cannot take so easily
Correct.
to wash away.
okay, he also submits that the,
Otherwise, government
that
will not be
the,
able
that,
to do
that the
anything.
notification dated 29/6/2024 is a policy decision of the government and the same cannot be overlooked by this court, even though
So easily.
decisions may have been made to the contrary. Next part. On considering the judgments quoted above and also a recent decision of this court in the case of in WPC 2591/2024, Mahir Ali and another versus State of Assam and Assam and 6 others. Wherein
Paragraph 14, madam.
Huh?
Paragraph 14.
wherein it was held that allowing the respondent number 7 therein to operate the fishery without any tender notice beyond the settlement period was illegal. This court is of the view that the of the view that the decision of the respondent to allow the respondents to continue to operate the which market?
Kadong market.
Kadong, KDONG, Kadong market
Under Mondi Ancillary Concern.
temporarily with effect from 1/7/2024. Beyond the previous settlement, beyond the settlement period made in terms of NIT cannot be allowed to continue. Accordingly, the respondent number 4, accordingly, the state respondent shall ensure that the respondent number 4 is not allowed to continue to operate the Kadong market beyond July 2024 unless the same is done in pursuance to a tender notice. Full stop. This would be in consonance with the orders passed in Koheshwar Barali versus State of Assam, Koheshwar Barali Supra, Ali Akbar Supra, and Mahir Ali and another Supra. This is the matter on 19. Or you want it before that for your judgment? If you can bring, I will change it.
on it may be fixed on 19, I may provide the citation day after tomorrow or day tomorrow also.
Leave the matter on 19. By which date the respondent shall file the affidavit. But I don't think you have got any chance of, with regard to challenge to the decision of the state to have a modified NIT.
They can modify the guideline, my lord. They can regulate the market price also.
They can regulate the,
But-
they have, you have to regulate the market price.
That
You
will
have
be
got to
better.
have a reserve price. A reserve price
Now-
so that they
now
don't
they
go
are-
too exorbitant.
Lord, in that item 1 order, your lordship passed an order, the public interest shall prevail over private interest.
Public interest,
So
private interest.
this is also applicable in this case, because 3,21,000 is his bid value.
Acha, one thing you're right.
And earlier 79,000 was only.
Anyway, you just
So
right. one thing.
exorbitant, so
Yes,
it is
yes, right.
harassment to.
That's right. The panchayat, the Anchalik Panchayat
Anchalik Panchayat.
shall operate the market till
Modified NIT.
till a modified NIT is issued by the state government. Full stop. Further, on perusing the reasons for giving the for issuing the impugned notification dated 29/6/2024, comma, it appears that the same has been made in the interest of the general public.
It has been reflected in the earlier course of mine.
Acha, but it has to be reflected here again.
Earlier
Reflected there.
clause.
We'll do it.
No, no, in this case, not mentioned.
No, we'll reflect it later.
Yeah.
You just reflect it, huh? You just copy paste them.
Okay.
19.
In item number 2, the matter is different. In this item already settlement was issued, lordship.
Oh, in item 2 settlement was issued.
Already issued, lordship. Page number 24, lordship, annexure 2.
Okay, give me item 2. Settlement already issued.
Yes, lordship. Prior to.
And then
3 days
you
prior-
call the additional AG. Okay. Then why were you keeping quiet?
It was legal.
Huh? Yes, in item 2, it seems settlement has already been issued.
Item 2.
Kindly
Your
pay-
lordship, this is not the order of settlement. This is the proposal for settlement.
Okay, proposal for settlement.
Proposal for settlement.
No, lordship.
The wrong translation, your lordship.
Let us see. Okay, wrong translation. Okay.
প্রস্তাব করা হয়েছে। That
Okay.
means that it's a proposal only.
Okay, in just out here, you just put in the additional AG submission. You just say that though the petitioner is trying to make out a case that a settlement has been made for the said market,
Yes, lordship.
comma, it is only a proposal for settlement and not a settlement order. Everything will remain. So it's only with regard to whether it's a settlement or not.
Yes, sir.
It's not a settlement, that's what you say. Will,
This
huh?
case was lead by Sir S. Thakur. He's on he's on leave, lordship, due to his father's death.
but it's your duty to give a correct translation of the vernacular.
Lordship, as per notice, we had translated properly. Lordship,
Please read,
in Assamese, lordship,
please help.
Your lordship, in Assamese, your lordship, উল্লেখিত ধনরাশি জমা নিদিলে বজাৰ বন্দোবস্তিৰ এই প্ৰস্তাৱ means proposal, your lordship, not decision, the order, your lordship. This is not the order of settlement. This is proposal of settlement, your lordship.
lordship, kindly peruse the subject of this letter. Lordship, regarding the settlement of Huragam Biweekly Market for the Panchayat financial year 2024-25, lordship, subject matter is that of.
So what?
Lordship,
So what? In a NIT,
lordship, kindly peruse the first paragraph in Assamese, lordship.
okay, no, I need a third party to do it. You do it. Which page is it? Which page?
Page number 27. Where did it?
No, he'll do it.
First paragraph. সিদ্ধান্ত গ্রহণ করেছে। Decision has already taken.
whether he has deposited his security amount, your lordship.
No, Lordship, সিদ্ধান্ত গ্রহণ করেছে।
Final decision. It's a proposal.
Hey, Robert.
He says it's a proposal.
It's a proposal, your lordship.
সিদ্ধান্ত গ্রহণ করেছে।
The resolution adopted in the meeting, your lordship.
Any agreement signed?
No, nothing. He has not deposited anything, your lordship.
Kindly, please let it lead by as what our children.
No, that's enough.
Obliged.
Yes, FCI. Additional affidavit.
My lord, we will filing the rejoinder affidavit now.
Not rejoinder, additional affidavit. Rejoinder they have filed.
Lordship, in the very last date of hearing also, they contended the same, and the lordship, the matter is very prima facie nature, and it can be disposed of, very, at the very outset, my lord.
No, you see, it's not that. On the last date, the FCI for the first time had prayed for filing additional affidavit to the affidavit in reply.
Already, my lord, they have filed the, affidavit in reply.
They have filed
Affidavit
affidavit.
in opposition, they have already filed.
Correct.
My lord, the person was an official tour and returned last evening, that's why.
He was an official tour.
Uh,
So
So that's why we'll file the affidavit now.
when? When today?
Today.
Today you're filing? Oh, very good. Look, you're filing today.
Lordship, can you, please provide a short date, kindly provide a short date for this?
Okay, right, miss.
2 weeks. Miss,
Lordship,
Why 2 weeks? You
I-
said today you're filing it. Why 2 weeks?
I am appearing on behalf of BKC.
No, madam, one thing, please understand. Are you filing your additional affidavit today? Then why do you need 2 weeks? 2 weeks for what? What is your name?
My name is Janmon Talukdar.
Tapan Talukdar.
Talukdar.
J Talukdar. J Talukdar appearing on behalf of Mr. BK Singh, learned standing counsel for the FCI, submits that additional affidavit to the affidavit in reply submitted by the petitioner will be filed during the course of the day. Today, no? During the course of the day. Accordingly, leave this matter.
4th of August.
Huh?
4th of August, my lord.
6.
6th. I think 6.
4th of August is
Lordship.
anyway Sunday.
Lordship, kindly, can you, mention that if they can provide me the copy by today itself?
If they don't give you a copy, they cannot file it.
Lordship, last time it was quite delay in providing the affidavit in opposition, because of which.
Yeah, Mr. Counsel, we cannot spoon feed you. But no, beta, I have this medicine, you know. That too they'll give you. Yes, item? Item. Okay, yes.
Six for the GMC is the main part.
Yes.
Main basis the lordship.
So you're boring well. Extension has not been granted. huh?
My boring unit was closed down, it was sealed, and they have seized certain items from my boring unit, and they have not issued any kind of seizure memo, no notice, no hearing was given. And despite that, lordship, they said that there is a complaint against me. Only on pestering, they said that there is a complaint against me. That is a verbal communication, and no investigation was done on that.
What to do?
GMC is the party lordship. GMC is the party.
Yes, what to do?
Here I have filed an affidavit, my lord. In that, my lord, section 6 of the. Before getting the trade license, you have to follow the section 6 of the Assam Groundwater Control and Regulation Act. That had to be conditioned. They have to get an approved from that section
Lordship,
6.
if I may
And then
take-
after a trade license can be taken, madam.
if I may take your lordship to the annexure number 429, wherein after the closure of my unit, I filed a representation with the respondent authorities. On that basis, they have issued an order, Lordship. Lordship, may kindly take up annexure number 4.
Page,
Page
page,
29.
page 29, yes.
Uh,
Order issued by the GMC.
Yes, Lordship.
Huh.
Here it is written, peruse the order passed by the Honorable Guwahati High Court dated 13/9/2018 regarding granting of trade license for operating deep tube well for extracting groundwater. The petitioner, Shri Manoj Kumar Chauhan, filed the petition dated so and so requesting permission for extracting groundwater through deep tube well. The chairman, appeal and member, mayor in council, GMC, considered the matter of the petitioner and processed the file for necessary views from the concerned authority. After considering the views of the concerned authority of GMC, the chairman, appeal and member, mayor in council, GMC, concluded the matter by deciding that the trade license for operating deep tube well for extracting groundwater may be granted on obtaining valid permission from Central Groundwater Board. Here it is very clear that trade license can be given only after obtaining permission from the Central Groundwater Board, which we obtained, Lordship. We have filed an additional affidavit in regard to that.
That a trade license operating may be granted.
From the Central Groundwater Board, Northeastern region, which may further be produced in the GMC for granting the trade license.
No, okay, okay. Just a minute. Now, what is this section 6? What is it? This is rule 6 or section? What is it? Section 6. Any user of groundwater designed to sink a well can apply to the state authority in the prescribed form for application. Yes, so madam, this section 6 of the act is required, of the act of 2012 is required to be followed.
They are the authority. They have an online portal, Lordship, where they issue the trade license. They have issued the trade license. That is the format how it is to be.
No, madam, please understand one thing. The law requires you to apply to the state authority for grant of permit to extract and use groundwater. Correct. Now, this state authority is the Assam Groundwater Authority established. Where is this Assam Groundwater Authority? So you have got to make an application to them.
Lordship, the process through which they are issuing the permissions herein is that through the GMP portal, one gets to issue a trade license, Lordship. One has to issue a trade license since they are able to issue those trade licenses. That is how I obtained it. Had it not been a procedure, I could not have obtained it, Lordship. I obtained that trade license. After that, when they said that there is a complaint of the reason they have cited, I approached the authorities saying that you please open my groundwater unit. On that basis, they have issued this order, which is the annexure 429, Lordship. This is the GMC. This is issued by.
When was the trade license given to you?
License was given to me 19/4/23, Lordship. It was valid till 2024, Lordship. And
It was given to you in 23.
yes, Lordship.
Was it given to you in terms of this act that is mentioned?
Lordship, one thing that I want to make it clear herein is that according to this order that was issued by GMC, they said that they can issue a trade license for operating the tube well, provided I get a certificate from the Central Groundwater Authority. That is the only requirement they have cited here.
Madam, just because someone writes a letter, can that letter supersede a law?
Lordship, definitely it cannot.
Then,
hearing-
madam, please. As per this, the Assam Groundwater Control and Regulation Act 2012, what does it say at section 6? Have you read it?
Yes, Lordship.
What does it say?
We have to apply to the authority.
Have you applied to the authority?
Lordship, herein I was asked to get a
Huh?
no objection.
Huh?
Herein I was asked to get a no objection from the Central Authority. They are the.
Madam, they might tell you to do, they might ask you to go and jump in the lake. Will you do that?
If,
You see, when there is a provision, as per the law, to be followed. You have to follow that. Just because they want you to go on a merry-go-round or a wild goose chase, doesn't mean that you have got to follow their law. You have got to follow the law, the statutory law. So section 6 out here provides for grant of permit to extract and use groundwater in the notified area. Where is the law that says that for this extraction of water, GMC will give it to you straight away?
Lordship, if they cannot, then how come they're issuing the trade license?
If they had given to you in violation of the law earlier, does it mean that a wrong that has been committed earlier should continue to be committed?
This is not a one-off case, Lordship. Everybody is
Madam,
getting
what
this
a-
permit. If that is the procedure followed by
This
everyone,
is,
that has
now
been
the
followed.
problem is for this court, the law has been placed in front of me. Can I say, no, forget it. Don't follow this law. Follow their law.
Lordship, one thing that I just want to know from him, what is exactly the procedure, if he may explain it?
No, you see,
How exactly to approach this? Because I want operation of my tube well. I cannot keep on running like this because I'm a very petty small businessman, Lordship. If he may explain the procedure, I can go about it so that he do not have to do all these things, because he has also seized my items, Lordship, for which he has not issued any kind of memo or he has not even returned it.
okay, where is this state
What is the
authority, this Assam State Groundwater Authority, where are they?
There is a group, matlab, there is a committee, matlab, it is irrigation department, you have to apply, matlab. Irrigation department.
In the
There is-
irrigation
there is-
department,
There is
this is made by whom? Wait.
This is, lots will take up my affidavit, man, for how this law has come. In paragraph 7, I have stated, man. Because there was a PIL, rampant extraction of water. was
Groundwater
going on.
extraction.
Thereafter, the board directed to make a law, then this law has come in. Paragraph, running page number 33, paragraph number 7.
Running page 33, additional affidavit.
In my affidavit, man.
Additional affidavit.
No, my lord, my affidavit filed by one Miganko Chaudhary.
Page 33? There's no 33.
CL number 33, running page number 33.
Running page 33. Where is the running page 33?
Then my affidavit filed by on Miganko Chaudhary.
I don't know, just
in
show him,
paragraph
I don't
number
know,
7.
just show him. He has his own pagination, I have my own pagination.
Yes, pagination has changed, my lord.
Yes, so if it has changed, what to do?
Well,
Either I run after you and change the pages of the court file, or you run after the registry.
39, my lord.
Page 39.
39.
Yes. What does
Paragraph
it
number
say?
7, my lord.
Yes. Yes.
No, that as regard to the statement in paragraph 8 of the petition, the answering deponent beg to state that based on the order passed in PIL number so and so, instituted against the rampant illegal boring throughout the city of Guwahati, the state enacted the Assam Groundwater Control and Regulation Act 2012.
But that much I know.
That
Who is the state authority? Where is their office?
office in the irrigation department, my lord.
Irrigation department.
Presently, the irrigation department in Chanmari.
So we do not have to apply to GMC since we
No.
are issuing the trade license.
No.
You go to the state authority in the irrigation department. You ask for this under section 6. You ask for it. And once they give you that, then you go to the GMC and ask for the trade license.
Lordship, I can do that. However, in the meanwhile, Lordship may also observe that the things that were seized by them, that should be returned to me. Because there was no,
What was his?
there were certain pipes, certain things which were required for the boring well to run the unit. They have seized it without issuing any Caesar memo, Lordship. I'm ready to come.
Any affidavit on that?
That
Not
is-
on that, my lord.
He is not on that, but that is one of the reasons, because I am a very small businessman, Lordship. I have invested a lot of money in it. How am I going to survive without my items, Lordship?
Madam, the problem is, yes, what have you seized? Mr. Bora, you obtain instructions. What have you seized?
Paragraph number 7.
Which para?
Para 5 law. Page number 9.
Madam, you also, no particulars, you have said sealed by seizing certain machinery. Failure.
The
Vital for, no, you should
Yes, sir.
say pipe, this much size, this much length.
Everything has to be.
Something should be, I mean, this is like, giving a very generalized view, nothing is clear.
Lordship, even them, it is not their authority to seize something without.
Madam, what has
looking
been seized? You tell me what has been seized.
Lordship, there are pipes, there are rings that we use for the.
I, there
There are
are
certain rings probably. which we
rings.
use.
Where have you said rings?
Lordship, it is not very specific
Where?
here, but that could be observed, Lordship. The things that were taken by them, because since they.
How do we know? Unless you tell us what was taken, supposing they say that we took only one pipe, then what will happen?
In that case, Lordship.
But these are questions of fact.
In that case, Lordship, I may seek instructions from my client so that I can put it before your Lordship, what are the things they have seen, and in that light, Lordship may pass an order on the next page.
See, the only thing we can say is that whatever seized materials they have taken should be given back to you. We do not know what they have seized. You have not said what they have seized.
Lordship, just to make it specific, I would like to file an affidavit or I would like to bring it into the record, Lordship, so that Lordship can pass a specific order in regard to that.
No, no. You see, I cannot pass a specific order because now whatever materials that you may mention now in your additional affidavit would have to be admitted by them. This is a question of fact. We cannot say that what you have said is the gospel truth. Cannot say that.
But then again,
So that is
their
what,
action is also illegal, Lordship.
maybe. But that is the problem. You at the first instance should have said this has been taken. A pipe which is around 5 feet long, 3 inches in diameter, or some machinery, some water pump, or something, Butley Boy water pump or a Kirloskar water pump having 110 watts or this many volts. I mean, it has to be specific. This is a writ court. This is not a civil court where evidence can be led. So best we can say is that whatever has been returned, be returned. And if you find that what they have returned is not what they have taken, you file a civil case, civil court or something.
Lords will turn to paragraph number 15 of the petition, madam. They have said that the machinery has been seized, boring well, and what is the reply, my lord? Paragraph 15.
Yes.
Paragraph 15, my lord, that had been denied, my lord. Categorically denied the baseless allegation. And it is that statement in maybe in paragraph number 5, 6, and 7. They have already have denied it, my lord.
Paragraph
Paragraph 15 down below, my lord.
of the affidavit of the respondent number.
My lord, paragraph 15 of the petition, my lord.
Paragraph 15 of the petition.
The petitioner may be allowed to resume the operation of the boarding
Just a minute.
unit.
Where are you? The petitioner may be allowed to.
Vague, though it says vague, though it says the machinery is seized.
This is neither here nor there.
No, I have denied it, my lord.
Huh?
I have denied the
Where have you denied?
Paragraph number 9
Of affidavit of?
of the affidavit, my lord. Just now, lordship had gone through the affidavit, my lord.
Huh?
Page 39, my lord, thereafter, paragraph number 9 of my affidavit.
Paragraph 9.
Paragraph 9.
Paragraph 9 is at page 40.
Paragraph 9.
Huh?
Yes, lord. Paragraph number.
She has denied it.
But Lordship, do they deny that they have sealed my unit without?
No,
receiving
the
notice?
sealing, though, okay. Sealing, they have sealed.
Lordship, is that legal?
No, madam. Please try to understand. This is not a fish market where, you This is, and another thing is that, you see, this is a writ court. In a writ court, the issue is basically on law. Okay. In a civil court, the issue is basically on facts. So now your submission or your allegation that they have taken some materials from your site has been denied by them. Now that is a question of fact. Whether they have taken or not is a question of fact. And once they have denied it, we cannot go into that question because evidence has to be led. You'll have to go to the civil court for that. But that issue now stands closed because they have denied this. They've said baseless allegation. According to you, might not be baseless, but it's your word against theirs. That's the problem. So the only thing that can be done now is if you want your boring well license, you go take this from the appropriate authority, then you go to the GMC and ask for a trade license on the basis of that. That's all.
Yep.
No, that's all. Isn't it?
That's all, my lord. Further, this is a precondition, section 6. You have to do it.
Okay, right. Heard Miss
And pay.
N. Begum, learned counsel for the petitioner, and Mr. S. Bora, learned standing counsel.
GMC, my lord.
GM,
My lord, both, all the respondents, GDD and GMC.
all the respondents,
All the-
appearing for all the respondents. What was the period of your license earlier?
It's a year, Lordship, 19/4/23 to 31/3/2020.
Lords, you will find that license in page number 28.
20.
One is a 20 and the license which we are challenging now is a 20.
Okay, right. The you just take this order dated 6/10/23, para 2. Huh? In this para 2, after the second sentence, just one thing you just write. The petitioner was granted a what license is this?
This is my lord, boarding water supply.
Was granted a license for boring for extraction of water through a tube well, which was valid till 31/3/2023. Okay. By the GMC Guwahati. And so thereafter, then continue. Then next para. Mr. S. Bora, the learned standing counsel for the GDD and GMC, submits that.
I may prove, Lordship, this is a license which is valid
Huh?
31/3/2024.
24.
My lord, 28, there is a 20, up to 24.
Huh?
Next page, my lord, 28. Page number 28, Lords, you will find it up
Okay.
to 31st March 2024.
Which was valid till
31st March.
31/3/2024. Huh? The Mr. S. Bora, learned standing counsel GDD and GMC, submits that the petitioner would first have to make an application to the state authority under the Assam Groundwater Control and Regulation Act, 2012. Hereinafter referred to as the 2012 Act. For grant of permit to extract and use groundwater. Full stop. Thereafter. No, not thereafter. Say, once permit is granted, by the state authority, comma, the petitioner should make a application to the GMC for grant of a trade license for extraction of groundwater through deep tube well boring. Correct?
In fact, not extra, now he will go for sale, trade, sale of.
Acha, for extraction and sale, huh? Extraction and sale. In terms of what? In terms of which act?
But in,
For trade license.
trade license section 180 of the GMC Act 1971,
In terms of section 180
of the GMC Act
of the GMC
1971.
Act, comma 1971. That's all.
That's
Full stop. He further submits that the state authority constituted under the 2012 Act is a body under the Irrigation Department, Government of Assam, comma, which office is located in
Sanmari.
Chanmari, Guwahati,
Three.
Lordship, one thing that I want to point out is that since in their own letter last time, they said that the requirement is to obtain a valid permission from the central groundwater body. Lordship,
Forget it, now the law is here.
So
it is not required, Lordship. Since they rejected it on that ground, they said that is the only reason.
I have recorded this submission. Okay, so that other letter is of no use. The letter that she's mentioned.
no, that is of no use, because the law is that the Assam
So stop.
Act.
Mr. Bora submits that. Where is that letter?
Lordship, at
Page
page number
29.
29.
Submits that the order dated 28/8/2023, order number GCL/33/2023, dated 28/8/2023, issued by Sasanka Jyoti Deka, member, office of the GMC, to the effect that the petitioner should obtain a valid permission from the Central Groundwater Board, comma, Northeastern Region, and thereafter approach the GMC for grant of a trade license is an incorrect direction / information given, comma, inasmuch as the petitioner would first have to approach the state authority under the 2012 Act and thereafter approach this GMC for a trade license. So, next. Para. I have heard the learned counsels for the part. First, as can be seen from the submission, that's right. Section 6 of the 2012 Act. Section H, section 2(H) and section 6 of the 2012 Act states as follows. Once a permit is granted by the state authority under the 2012 Act, the petitioner would have to approach the GMC for grant of a trade license under the GMC Act,
Section 180,
section 180 of the GMC Act,
1971.
1971.
70.
Yes, sir. In view of the procedure to be followed for grant of a permit for deep well boring and grant of trade license in terms of the GMC Act being made clear to the petitioner, the petitioner is given the liberty to approach the concerned authority as required under the 2012 Act and the GMC Act 1971. The writ petitions accordingly disposed. So you want me to make any mention of your paraphernalia and all? No.
Lordship, if that we said that if anything was taken, that may be returned.
Okay, just write in the petitioner's submission, no? Just write the petitioner's counsel submits that at the time of sealing of the well,
Yes, a unit. board
of
supply.
the water supply, petitioner's water supply unit, some pipes and machinery were taken by the GMC
Without issue.
without issuing any seizure memo. Pusta. Then Mr. S. Bora, huh? Where summary, right? Mr. S. Bora further submit that the stand taken by the petitioner that the GMC had seized some pipes and machinery without issuing any seizure memo is a baseless allegation. So that much. Okay.
Problem.
And then at the end, when you just say one more thing, at the end, with regard to the stand of the petitioner, that some materials were seized from his water extraction unit. This court is of the view that if any material belonging to the petitioner has been seized, the same should be returned to the petition. That's all.
Detail.
May I please lordship? Your lordship or on this 25/7/24, this notice notice has been issued to respondent number 5.
4 to 6.
Regarding other respondents, my lord, notice is complete, service is complete, only respondent number 5, my lord. The 25/7/2024, the office note says that notice was issued, but the service is awaited.
So notice was issued on 25/7.
Yes.
Yes. You have done this because you did not come last time.
Yes, Lord, I am very sorry.
Ah.
Please tell me to my lord, somehow missed.
Right. No, right. Office note indicates that notice was issued to the respondent number 5 on 25/7. Accordingly, await service report. List the matter after 3 weeks. 4 weeks. 4 weeks.
No, please, your lordship.
Acha, wait a minute. Sorry, I got mixed up. Anyway, he's gone. Who is for the? Just give me item eight. You see, there is this Tourism Corporation. Assam Tourism Corporation. Just a minute. Item eight. This is the Assam Tourism Development
Yes, yes.
Corporation.
Yes.
Who is appearing? Who can appear for this?
Is standing the council, own councillor.
Who is he?
Engage lordship. No specific council is there.
No specific council.
1, 2, and 6 I am appearing.
And in fact, my lord, if he is appearing for 1.
Look,
to 6,
because your case is that you have constructed a building on government land and you have taken the compensation amount.
No, my lord, that Assam type house and is a regarding plantation tree, my lord, regarding that compensation amount given to me.
Why?
And if they
You are not the landowner.
No, my lord, if they are agreed, they can file a objection under that land.
What happened to the criminal case?
It is pending.
Pending.
Regarding my lord, that seizure of these articles.
No,
my
but
lord,
then
it
you
is
see, this matter is of 2019. Why is this Assam Tourism Development Corporation? You are for whom? 3 also.
1, 2, no lordship. 1 and 2.
126.
Can't you inform the development corporation regarding this case? This is a very important case. You see, what has happened is, he was looking after the guest house. And he constructed a house on not his land, near where he's working. And that land was acquired, he pocketed the money.
That was constructed from my pocket, that's why. So
But
compensation.
yes,
There is a report.
you constructed it only to get the compensation.
No, my lord.
Then the
no.
landowner did not get the compensation. The landowner is the Tourism Development Corporation.
But there is a provision under Land Acquisition Act, my lord. They can, because instead, my lord, they seized my article. That's all this article.
We'll have to see that. We'll have to.
Yes, sir. They have seized, my lord. That is
What?
the only thing. My lord.
That sees what?
My all these articles regarding my lord, operating this resort, my lord. I have, my lord, annexed this list, my lord.
Anyway, right, what have I said? Heard, Mr.
I'm sorry.
M. Sharma, learned counsel for the petitioner. Mr. S. S. Roy appears for respondents number
1, 2, and 6, Lord.
1, 2, and 6. Office note dated 25/7/2024 states that notice has been issued upon the respondent number 5. That is the General Manager, Assam Tourism Development Corporation Limited. On 25/7/24. Await service report. List the matter on, give a date. Out of 4 weeks. Out of 4 weeks, give a date. 3rd September. Then you write, Mr. S. S. Roy submits that he will inform the Managing Director of the Assam Tourism Development Corporation Limited with regard to the pendency of this case.
My lord, criminal case, what I had instruction, my lord. The prosecution witness, my lord, have not turned up for a number of years. This case is back.
And what has happened to the money? You have been allowed to do something with the money now.
My lord, money is there, but only thing is that, my lord, my articles have been seized. That is there. The table, dining table is there, deep freezer is there, my lord. And
Oh,
is there wall and
why shouldn't you give back the money to the corporation?
That land acquisition authority that is there, my lord, they have to file application there. Instead, they have filed FIR and it's, my lord. seized it.
Next time you tell me some vacant land, I will also construct a house and pay the compensation.
My lord, in this matter, as per office note dated 25/7/24, my lord, neither the ID card nor answered notice has been received.
What to do?
My lord,
I had 2 is 4 and 2 6. Akash, the principal secretary, BTC. Where is Miss R.B. Bora? You tell her to come. R.B. Bora.
my lord.
Lordship, here yesterday we filed our affidavit, Lordship. Lordship,
Yeah, for whom?
I'm for KAC, Lordship, Karbi Anglong Autonomous Council. Let this matter come after next week, Lordship. Along with our affidavit.
Where is Miss Kemprai? Who is appearing for the for Kala? For respondent number 7.
I'm appearing for the Kala.
You are appearing for Kala.
Yes, sir.
So was the compensation amount deposited with you?
That instruction I have to take.
That instruction you don't have. Because affidavit of respondent number 1 and 2 states that compensation has been deposited with you.
Lordship.
And this matters of 23 and you don't even have that instruction. We'll ask him to come here, I think, Joint
Okay.
Secretary.
Appeal is also pending before the Joint Secretary, Lordship.
Mr.
It
Counsel,
is
there is
fixed on
a,
second.
there-
It is
there-
fixed on second.
my petitioner has received one notice from WhatsApp, okay? So I think from respondent number 7, directing her to appear before respondent number 7 on 2/8 August.
To it. Okay, we'll fix, you go on to it,
Yes,
you go on to it.
to it.
Because he has received the money as per respondent number 1 and 2 affidavit. Respondent number 7 has received the money. He has to disburse the amount. Now we'll catch him. He's putting it probably in some bank account and he's taking the interest probably. Hai?
Let him appear on second lordship along with all these documents.
And then after that, we'll fix the case here. And if nothing is done, I'm going to call the respondent number 7 here. Then probably make a criminal case against him. Money has been given by respondent number 1 and 2 for disbursement to the landholders.
We have mentioned in the affidavit lordship yesterday, we have filed our affidavit.
What?
We have filed our affidavit yesterday lordship.
You filed an affidavit? Oh,
Yes.
what did you say in your affidavit? Is it here?
It is not on the record lordship.
Affidavit filed by whom?
By the Kala lordship.
By 7?
Yes, lordship.
And has he admitted to the money being deposited with him?
I have not gone through the affidavit.
I will go through, give me the. Have you been given a copy of the affidavit?
Yes, lordship.
You come to para 7. Please read para 7.
The petitioner claimed compensations in respect of the dock number 70, pata number 30 of village Naharjan, and the description of the land published in the Gazette notification dated 24/3/2022 is in respect of dock number 70, pata number 70 of village Naharjan. And
So there is a slight difference in the PP number.
yes, lordship, my petitioner pata number is 30, but
30.
in their notification, pata number is 70.
And that 17 is whose name? Now, you see, supposing there is a difference in name, a difference in the DAG number or PP number. Who is the owner of that PP number in the Gazette notification?
Here notification is annexed.
Huh?
Notification is annexed lordship.
Pata number 70 is in the name of respondent number 10
Ten.
in notification.
Private respondent.
Private respondent. I have taken steps also, but notice has been unserved, lordship. So in last order, direction was not given, lordship, to take fresh step. Should I take fresh step or not, lordship?
No need. What have we said, that complete or not? Have we said that? steps taken, that's point number 10. Let us see what is the,
Rosima Court also said that 19.
you were supposed to take fresh steps.
Yes, Lordship. But in last order, it was not reflected. That's why I've not taken step.
Okay, so you, you take fresh steps today. Okay. Anyway, so you have to take your original documents to him. You do that. Petition, response number 10 also. Right. Heard Miss KLR Yanthan, learned counsel for the petitioner. Mr.
R.S. Ronghan.
R.S. Ronghan
Ronghan.
appears for the respondent number 7,
Lordship, respondent number 429, Lordship.
429, and submits that affidavit on behalf of the respondent number 7 has been filed today, yesterday,
Lordship.
has been filed yesterday. First of all, just need to place the same on record. Full stop. A perusal of the copy of the affidavit filed by the respondent number 7. A perusal of the copy, which is with the government advocate, shows that the respondent number 7 has not stated in his affidavit as to whether respondent number 1 and 2 had deposited the compensation amount with the respondent number 7 for in respect of land covered by DAG number 70, PP number 30 of village Naharjan / DAG number 70, PP number 70 of village Naharjan. One is 30 and one is 70. 70. Both are. So the first one will be DAG number 70, PP number 30. Second one is DAG 70, PP also 70. However, the affidavit of the respondent number 7 states that the petitioner and the respondent number 10 have been called to his office to appear before him on 2/8/2024. Accordingly, leave this matter on when?
Next week.
9/8. Ms. VL Singh appears for
Respondent 1 and 2.
1 and 2.
Deeply objected.
No one appears for the parties. Leaves the matter after 2 weeks.
May I please have the floor?
May I please, your Lordship, the conducting counsel, Mr. KP Pathak is in another court, he is in midst of hearing, so it may be taken after some time for the time being.
What should be in the second half? As a matter in the lower court also. Second half. The Pathak was supposed to obtain instruction as to while calculating electricity bill, whether sanction load is also to be taken into consideration. That was your lordship's order, dated 9/5.
So when do you want?
Any day your lordship desires.
You said after second half, or you want to go to district court?
I want to go to this. I can go now, I can come back by 2 o'clock.
Okay, whatever.
Much of it.
2. No one appears for the parties. This is the matter after 2 weeks.
In Lordship, Assam Muslim Marriage and Divorce Registration Act, it has been repealed. And the date repeal have been silenced before the division bench.
Huh?
Assam Muslim Marriage and Divorce Registration Act, Lordship. The date has been repealed,
It has been repealed.
Lordship. Against the that repeal, my lord, they have prepared the petition before the division bench.
And what is this? This case is against
Those
us.
are other cases. But in this case, my lord, there is no case because of that. So long that this repeal order is not set aside, it has got no value. All the causes have been relieved from their jobs.
What to do? No one appears for the petition.
Their license has already been cancelled. So
Oh.
there's no more, my lord, no more in the Kadi and. my lord,
There's no Qazi.
No, MMR and Kadi.
Okay, right. No one appears for the petitioners. Mr. P. Handing appears for, J. Handing
JND.
appears for
So 1 to 4 votes.
1 to 4. One. Mr. M.U. Mahmood appears for respondent number 5.
Five.
Anybody else? Nobody?
No.
The counsel for the respondents submit that. The present case has become infructuous in view of the repeal of the Muslim Marriage and Divorce Registration Act 1935. Where's the repeal order?
Lordship, I will give you.
Right, so and so, huh? The petition, the counsel for the respondent submit that in view of the repeal of the act, hereinafter referred to as the act, huh?
16 March 2024.
Right, notification dated
16 March 2024.
16 March 2024, issued by
By the, my lord, Secretary to the Government of Assam Legislative Department is put.
Secretary to Governor of Assam. Governor, government,
Government of Assam.
huh? Government of Assam,
Legislative Department.
legislative department. This is it's under a act, some
Lord,
section,
The
Under what?
213 Lordship.
Huh?
213 Constitution of India, that is repeal.
under
So I
issued
will
under
give them all that.
notification, just give the notification. Just print it out.
Only.
Right, the counsel for the party, the counsel for the respondent submit that in view of the repeal of the act, there are no more registered government qazis to discharge duties under the act. Full stop. Next paragraph. The petitioners herein are government qazis, comma, who are aggrieved by the activities of the respondent number 5, who is a registered qazi under the act.
Yes. I would hear. Second April.
The grievance of the petitioners is that the respondent number 5 has got defined jurisdiction over the villages of Betbari Muza, part of Bhabanipur Muza and part of Pakka Betbari Muza in the district of Barpeta, comma, within which he is required to discharge his duty, full stop. However, he has appointed agents in various parts of the state of Assam who are conducting marriages. Full stop. Accordingly, the respondent number 5 is acting beyond, is acting beyond his Respondent number 5 is, wait, huh. Is acting beyond his jurisdiction.
We have denied that to our affidavit.
Huh?
We have denied that to our affidavit.
Ah,
With some misunderstanding, some persons suppose pilot ship's record, but he is presently residing at Guwahati. So henceforth, there are nothing.
yes, so now they are saying that this act has been deleted. Repealed.
Our affidavit has this.
Whether it is notified or not, lordship. Ordinance of, yeah, lordship. I've already given the note.
Yeah, it's in the gazette.
Some other my lord, state lordship.
No, why should I keep it pending? Just look at this.
But the.
Just look at this. Just look at this. There's nothing else. Nothing remains. I'm not going to keep it pending this either.
But this is the ordinance lordship.
Whatever it is, it is ordinance or not, it is repealed.
Also a law.
In the next, assembly. It has to be accepted by the cabinet lordship, assembly. It is not a law lordship.
No, it is law until it is, I mean,
What
enacted by
happened?
the parliament or itself.
After some days lordship, my
Just
lord,
doing that.
my lord, after the repealing this act lordship, another act will come lordship. What will be that lordship?
ये delay जाओ ना. No. Whatever comes, that'll come.
That will come,
But
they will-
under this act, this entire issue has become infructuous.
Now, Qazis are working lordship.
No, no.
They are not working.
Government candidates are not,
Not working.
otherwise they will go to jail.
Then some other day lordship, I think.
No, there's nothing here, Mr. Council. You take it up, we'll take it up at 2 if you want. That's all. We'll take it up at 2 if you want. That's all. Nothing beyond that.
Unless the ordinance comes law lordship. How they act will be, my lord, the law. It will discuss in the my lord assembly lordship.
What you can do is we'll dispose it of now. If it is not done, then you come in a review. That's all. Come in a review, small 1-page review. We'll restore this. No point keeping it pending.
Yeah.
So what can we decide now?
My lord, with that observation, it may be.
No, I'm telling you, you do that. Okay, all right, what have I said? Full stop. However, no, on the other hand, next para, on the other hand, the stand of the respondent number 5 is that
The
He-
misunderstanding was there and they do more than us.
submits
We
that
have annexed that document.
they're exceeding their jurisdiction.
They
according-
are exceeding more than me.
Okay, okay.
Stanley said-
On the other hand, the stand of the respondent number 5, the stand of the respondent number, just submission. On the other hand, the stand of the respondent number 5 is that the petitioners are doing work beyond their jurisdiction. Full stop.
We have records.
No, I'm on. Full stop. The next para.
It is not.
Mr. J. Handik, learned counsel for the state respondents, has produced the notification dated 16/3/2024, issued by published in the Assam Gazette, which is the Assam Ordinance number 4 of 2024. Which is the Assam repealing ordinance 2024, which has repealed the Assam Muslim Marriages and Divorces Registration Act, 1935. Also, in view of the above ordinance, there is nothing left to adjudicate in the matter at this stage. Accordingly, the writ petition is closed due to the repeal of the Assam Muslim Marriages Divorce Registration Act wide the Assam repealing ordinance 2024. However, in the event the Assam Muslim Marriages and Divorce Registration Act 1935 is subsequently brought back to life, is it?
No, Lordship, the working of the Qazis, existing Qazis are continued, Lordship. Under the new law, it comes, Lordship.
No, it will be reference, Lordship. It is not like that, that it is the Assam Muslim marriage and again will come. They will brought in some other.
These are not
That
material.
will come, Lordship.
If any law is enacted, law automatically will follow that. So that observation is not necessary.
Well, that is necessary because, my lord, it is admitted case, Lordship. My lord, whether the respondent, my lord, worked beyond his jurisdiction or not.
No, but then we cannot decide that now. Right now it is repeat.
That is why, my lord, with observation liberty is necessary, Lordship.
Then you'll have to, unless your appointment as a Qazi is upheld in the new law, all that.
If upheld under new law, Lordship.
That you file later on.
My lord,
This is
the-
causing confusion. You cut that. This is, what have I said? No, before that.
With liberty to appropriate application, my lord, if necessary, if sir might have, that may observation. May be to the court. That will need to be clear, Lordship. My lord, otherwise, my lord, this is a public.
There's nothing here in this law. In this law, there's nothing to decide.
As per my instruction, Qazis are working, Lordship.
No, it is, it is a wrong submission, my understanding.
Even if they're working under a repeal law. Even if they were working under a repeal law, invalid law.
Don't know, Lordship, but there is no notification. like-
Anyway, right, the notification dated 16/3/2024 is made a part of the record and marked as an extra act. That's all. You can always file.
Without any observation, Lordship, liberty.
Okay, just right. It is needless to add that if the petitioner is still aggrieved, in terms of any new law that might be promulgated, or if the repeal law is brought back to life, the petitioner may agitate the issue afresh.
Lordship.
Obligation.
Pending item 9.
What is this item?
Nine.
Madam, yes, we need your help.
Lordship, I shall take instruction. Dharanidhar Boro is
Huh?
Dharanidhar Boro is no longer Biren Pokon also no longer. Biren Pokon retired from service.
So you'll appear for them?
No,
No.
Biren Pokon and Dharanidhar Boro, I cannot appear.
What?
Biren Pokon and Dharanidhar Boro, I cannot appear.
You can appear for whom?
Actually, he has to plead.
I have already implemented.
Sujit Baglari Akasdeep.
That is respondent's number?
Four, five, and 6 mallet are newly implemented.
But I need as a vocal number from them.
You obtain instructions from them?
Plus.
Okay, Ms. R.B. Bora submits that she will obtain instructions from
Respondent number 4 and 6.
4 and 6.
4, 6, 5 and 6.
4, 5 and 6.
I need a copy.
Extra copies. You give one more. List the matter after 3 weeks.
See you, Lordship. I shall obtain.
Public delivery.
Deep level, Lordship.
my lord. But here there are two Gao Panchayats, my lord. I would like to take your lordship to page 12, my lord, annexure 3.
Yes.
My lord. May I read, my lord? This was issued in 1992, my lord. It is in the partial modification of the notification so and so dated 23/3/92. The governor of Assam is for administrative expediency pleased to reconstitute the Nazira subdivision within its headquarters at Nazira town, comprising of the area shown in the schedule below with immediate effect. Under the Nazira revenue cycle, my lord, comes Nazira Moza, Jokoli Moza, Atkel Moza, and Dopabor Moza. Now, my lord, under Dopabor Moza, there are two Gao Panchayat, which is Lengi Bor and Suka Pamela. So, my lord, in the next annexure, my lord, which is a WT message, page number 15, my lord, annexure 5. Annexure 5. The WT message which was issued by the Secretary of the Assam government. It says in respect of the reservation for the post of President, Vice President of the Gao Panchayat under Nazira Anchalik Panchayat will be done as follows. DCOM Sibsagar will do the reservation of 18 numbers of Gao Panchayat falling in the administrative area of the Sibsagar district, and DCOM Charaidev will do the reservation for the remaining two Gao Panchayat in the Nazira Anchalik Panchayat falling in the Charaidev district.
May I enter, Malab, for a second? It's a Malab, PNRD is the Malab Panchayat and Rural Development is the Malab main party here, Malab, but they are not main party, Malab. Because grievance against him, Malab, because reply to the paragraph 7, 8, 9, 10, 11, Malab, have to be given by the Panchayat department, Malab. Because delimitation is, Malab.
Administrative, my lord, the whole point is that, my lord, that these two Gao Panchayat should be under Nazira subdivision in the Sibsagar district, but that is now under Charaidev, my lord.
That reply has to be given by the Malab. It is instruction also received, Malab, wherein Malab, in this reply, Malab, it has to be given by the Panchayat and Rural Development Department. It's the necessary party here, Malab. Delimitation of my dog that Anchalik Panchayat, Gao Panchayat, Malab.
Chapter 6 here, my lord, there.
Huh? Better late than never.
My lord. Otherwise, my lord, again, it will be high.
Read them apart.
I don't know if this case will help you.
Lordship.
Delimitation.
Saraidev, Malad, Maidam is the Malad integral part of Saraidev district.
Miss Udas submits that the PNRD department is a necessary party in this case. Mr.
A.W. Amar.
A.
W. Amar.
A.W. Ahmad, Senate counsel for the petitioner, submits that he will file an application for impeachment of PNRD department. Accordingly, matter is adjourned for 3 weeks.
Deeply appreciated.
We'll finish.
I had a meeting with the officers yesterday, to try and understand what it exactly entails here. So I'll just try and explain it.
Let me read the last order.
Yes, yes.
I have forgotten.
9/5.
Hmm?
Order dated 9/5.
So is it same as this, your submission,
My submission is that this,
same as this?
this one, 26,
Is it same or not? Just say yes or no first of all. Is it same or not?
same or not?
Is your calculation, the method of calculating it, your calculation is the same as this?
Not sure, I'll have to ascertain, I'm not very good in math. I have to ascertain this.
Yes.
No, my case is
Just,
that,
just a minute. So even your submission is wrong. You are saying out here that the petitioner is to pay 1.5 crores in a way. But out here it says that 1.09 crore.
That is already on it. That order is already on record. He's
No.
got that order on it.
Then why did you make this submission on the last date?
No, that is regarding, because the assessment which your lordship was going through at page 48, that was regarding the previous order, which was under challenge before the appellate authority. So it was in connection with that statement at page 48 that I had made that submission.
Okay, tell me what is the case?
Yes.
Lord. The case of the petitioner is that it's a tea estate.
Where?
The allegation against it is that it has been found to be indulging in theft of electricity in the sense that the electricity meter in the garden premises on inspection has to be found tampered with. So he has been raised with the tea estate has been raised with an assessment bill.
They have raised the assessment bill.
Assessment bill as per section 126 of the Electricity Act. This is 126. As per section 126 of the Electricity Act. Now, my case is that the manner in which the assessment bill has been prepared, that is incorrect. Because the date on which the actual date from which the actual theft of electricity had taken place could not be ascertained. If it could not be ascertained, it should be the last 12 months. That is, as per section 126(5). And they have billed me at a higher figure. In order to get the electricity connection, I have paid 50% of that. And initially I have filed an appeal. That was not very fruitful. And thereafter I come before this honorable court. There was a review. I'm not.
How do you say that, now this is the method, the formula they have given?
Yeah. Now, my
now-
case is that
Hmm.
this 126, Electricity Act was rather, the 126(5) was notified from 15/6/2007. That is in the first order passed by this honorable court. Honorable Justice Rishikesh Roy,
Hmm.
as his lordship then was,
Hmm.
on 2/11/17.
So 15/6/2020, 2017,
2007.
2007.
And this board has been notified on 13/6/2007.
What has been notified?
This electricity supply code, which my learned friend is relying upon,
Code has been notified
on 13/6/2007.
13/6/2007.
Yes. So since this 126(5), has come into application from a later date, it is a later law which will prevail. In any case, the provisions of the code cannot override the provisions of the statute. And the statute does not say anything about sanctioned load or anything of that kind. The statute says if the date on which, from which the malpractice has taken place could not be ascertained, it will be one, last 12,
It will be,
last 12 months. Last
Yes.
12 months average is to be taken. Lordship will kindly see 126.5.
yes.
If the assessing officer reaches to the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. So, from the inspection report prepared by them, it nowhere, it can be found that the date from which the unauthorized use of electricity is.
So from the date of inspection, 1 month prior to, from 12 months prior to the date of
Yeah.
inspection.
That is my case.
Uh.
And I ought to be billed on that, in that manner. Now, this calculation which my learned friend has given, that I fail to understand. I need a little time to look into it.
Okay, so basically, your case is basically as per 125.6.
Yes.
It has to be twice the amount.
Twice that. And I have
That's
paid
all.
more
There's
than,
nothing else.
I have paid more than that, I am entitled to refund.
Okay, now, yes, you please explain to us. First of all, he says that the act only provides for twice the amount. Why should the code be followed? The code, the electricity code, why should it be followed? That is one. And number two is, now, this method of calculating the amount to be paid by him. How do you assess it, and
Yes.
how has it been made, and under what provision, what is the source of power?
Yes, I'll take your lordship to the entire thing.
Yeah.
So first, if I may take your lordship to 126.5 and 6. Your
Yes.
lordship. So 5 says if the assessing officer reaches to the conclusion that the unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. So it means, your lordship, if the period of unauthorized use can actually be ascertained, even
Then
if it
for
is
that
more
period.
or less, then the actual period will be taken into account. But if it cannot be ascertained, then it will be limited to 12 months. And the 126.6 says the assessment shall be made at a rate equal to twice the tariff applicable for the relevant category of services specified in subsection 5. So what my learned friend is effectively submitting is that in the previous 12 months, he had paid around 42 lakhs odd. So since it is twice that amount, he should pay around 84 lakhs something should be the amount essence. So that higher figure that we have arrived at 1,54 lakhs initially, but it was later revised, that should not have been done. Now there are, first I'll take your lordship to how that amount to your lordship that the petitioner paid, how that is assessed. Now, an electricity meter, your lordship, the meter calculates the number of units, colloquially, the number of units consumed by a consumer, and a tariff is fixed at a rate per unit, and that multiplied by the number of units is the actual monthly bill which a consumer has to pay.
Correct,
There
correct.
are some fixed charges, rentals, duties, etc., but that is in effect the principal sum. That unit, your lordship, what we colloquially call unit, that is arrived at, your lordship. What the meter actually calculates is a unit of measurement called kilowatt per hour, kWh. Your lordship, every electrical appliance, be it a bulb, a computer, or fan, it has the maximum number of electricity that it can consume. It is reflected in volts. So usually, so that is the amount of electricity that a device would require to operate. And the amount of electricity that it consumes from the connection, that is the current drawn. So the actual electricity consumed by that device
we get it by multiplying the volt into current, which is ampere. So kilovolt into ampere, we get something called kilowatt. Kilovolt into ampere, which gets something called
Wait a minute. Yeah. Kilovolt,
that is the
kilovolt.
that is
Ah.
the electricity that is consumed
Ah.
by a device
Ah.
into the current drawn, which is ampere. If we multiply that, we get something called kilowatt, kW. It's watt, but since it's reflected in multiples of thousands, it's kW. So the amount of watts of electricity consumed by a device per hour, kW into H, it's reflected as kWh, is what we call the unit, Your Lordship. That is what the meter calculates. The number of watts per hour. So it's reflected as kWh. Now, when a meter is is tampered, Your Lordship, the device cannot be tampered because that kilovolt will remain the same. The actual amount of electricity that the
Device will use.
that the device will use.
The kilovolt will remain.
That will remain the same. The time for which the meter has been running, that cannot be changed, Your Lordship, because that clock is automatic, Your Lordship. So what is tampered with is the current that is shown to be drawn by the meter, the ampere. So once that is tampered, Your Lordship, that the actual kWh, Your Lordship, which was actually consumed, that can never be ascertained. So if that cannot be ascertained, his actual consumption for the past 12 months, Your Lordship, cannot be estimated.
Correct.
If we leave that to the subjective satisfaction of the assessing officer, it will perhaps lead to arbitrariness. To give it some measure of subjectivity, Your Lordship, objectivity, the AERC has framed the supply code. In the supply code, a formula has been given to arrive at that kWh figure. That formula is, Your Lordship, the maximum connected load as per the agreement, because these are special circumstances. The maximum connected load of that consumer as per the agreement, which in this case was 620 kilowatt. The agreement, Your Lordship, will find
No, so what is the difference between the maximum connected load and the sanction load?
the sanction. What happens, Your Lordship, the maximum connected load, for example, in a category of consumer like the petitioner, the maximum connected load in his category is 620 kilowatt. Now, for a consumer, because otherwise for domestic consumers, it's same, Your Lordship. But for industrial consumers, what happens is, sometimes the industries do not consume the maximum connected load. So
that way, even a house may not.
Yes, but that benefit is not given to domestic consumers.
Huh?
That benefit is not given to domestic consumers. In industrial consumers, what happens is the sanction load, connected load is maximum connected load as per agreement is 620 kilowatt. Now, suppose in an industry like tea industry, it's seasonal, Your Lordship, because the plucking happens in one season and then the grinding and industrial stuff that is in one. So the actual consumption used, the actual electricity consumed, it is divided into two parts, the peak season and the off season. So during the peak season, only 65% of the connected load is billed. And during the off season, it can range from 65 to up to 105. So they can exceed that also. So it is on that basis that the appellate authority had in fact subsequently revised that 1 crore 50 lakhs was revised to 1 crore 5 because that peak season off season formula was not taken into account. In this case, his maximum connected load as per agreement is 620 kilowatt. Because that kWh cannot be arrived at a figure because the meter is tampered with, the formula that is given under the supply code is his maximum connected load, that is 620, into, there is a chart, Your Lordship, which gives an estimated monthly consumption of each category of consumer. So for tea and coffee plantations, it's fixed at 200 units per month. So it's 620 into 200 into 12. That so that we can arrive at the kWh.
My question is this. What is the difference between the connected load?
Yes,
And this sanction load? Isn't it the same basically?
The connected load and sanction load can be the same, Your Lordship.
That's what.
Yes.
It is that connected load, when it is sanctioned, it is on the sanction load. That's what.
When it is using, it.
No.
So, because the agreement itself says that which part of what has been sanctioned for which part of the year. So there is a difference between the connected load and the sanctioned load in some cases. Your Lordship.
Okay, no, you see, you're talking about industries.
Yes,
What about
Yes.
a big establishment? Supposing there's an office,
yes,
it's a 20-storied office
Yes.
building, one company.
Yes.
Then what will it be given?
then it will be the
It'll
same.
be same,
It will be-
same,
it will be
and
the
there is no question
Yes.
of peak season and
Yes,
non-peak
no,
season.
no, it will be the same. Your Lordship. It will be
What are you saying?
will
You're
be
not
the
all, you're still also not sure.
No, no, I was referring to his category.
No, you have got to be general. You cannot talk about peak season, non-peak season, because you have got to apply it to different circumstances.
Yes, Your Lordship.
So now supposing there's an office,
Hmm.
a big multinational company has got a 30 floor office.
Your Lordship.
Okay. So sanction load is say 620. Now what is the fully connected load for that?
The connected load cannot exceed the sanction. It
So-
might be lesser.
And the sanction load can be less or what?
No, Your Lordship, what
Or
happens?
sanction load can be more.
No, sanction load cannot be more, Your Lordship, because
So what is the difference between those two loads?
the sanction load, the sanction load is the actual, the amount of, maximum amount of electricity, Your Lordship, which the consumer can consume as per his agreement with the distribution license. The connected load, Your Lordship, is the actual amount of electricity consumed as per the actual physical amount of electricity consumed.
Yeah, I don't know. You see, there are things like transformers.
Lordship.
Transformers are fixed where, say there is a, say, High Court. High Court, I do not know this High Court, at least in Aizawl. We have got a separate transformer for our building. Now, that transformer might be a 500 kilowatt transformer, whatever, I don't know. But the electricity that we use may be around 250 only, not 500. Now, sanction load and full connected load, what is the, now, where do you place
Capacity of
them?
the transformer, Your Lordship, will be the sanction load,
Okay,
and the actual amount of devices connected to it or the electricity that is used under that transformer, that is the connected.
but a connected load can never be higher than the
It cannot
sanction.
be
load.
higher. If it's higher, then it will amount to unauthorized use of electricity.
The transformer will burn.
Might not sometimes, it might not, it might have, just because it's a 500 kilowatt or something, it may be able to take more. Sometimes, I mean, might not have to, but anyway. So out here, so the sanction load is not the issue,
No.
is it?
Here, we have calculated it on the basis of the connected load, because that's what the formula provides.
But the connected load can never be higher than the sanction load.
It cannot be higher than the sanction load. The connected load, Your Lordship, is 620 kilowatt. That is what the formula provides.
Then, if you do not know the exact amount of power that is being used, why don't you take the sanction load, since the sanction load will be the maximum load?
In his case, Your Lordship, the sanction load is actually less, because it's a seasonal industry.
Okay.
From April to
So
November,
sanction load is less.
April to November is 470, and from December to March is 190, Your Lordship, is actually lesser
Then 620.
than 650. That is the issue.
Okay, then
So since the KWH cannot be ascertained, the formula that is given under clause 5.A.4.4 is connected load into 200. That is the estimated consumption, monthly consumption of this category of consumer into 12, because 12 months. So
then that has to be again multiplied by 2.
no, the tariff has to be multiplied.
Our tariff has to be multiplied.
So we get the number of
Okay,
units.
so the rate will be costly. It's like buying, say diesel is 100 rupees, you'll be buying at 200 rupees.
200.
Huh.
So once we get that number of units, we have subtracted it from the actual units that the meter actually showed during that period. Because the difference between the consumption of the meter and the number of units that we arrive at after using this formula is the electricity loss that has been caused to the company because of his unauthorized electricity.
This come again, this part?
Yes. The number of units that the meter actually recorded during the last 12 months, that figure is subtracted from the number of units that we arrive at after multiplying 620 into 200 into 12 as per the formula. So the figure that we arrive at, that is the number of units of energy loss that has been caused to the distribution company due to his unauthorized use of electricity. That is multiplied by 6.75, that is his tariff for his category, into 2. twice the tariff. So that is how we arrived at that figure. But while that amount was calculated, the seasonal discount that should have been given to it
Was not.
was not granted. So we filed a review before the appellate authority. The appellate authority directed us to take that into
Lowered,
account.
so you have lowered it
We
down
have
to
lowered
one.
it. We have-
Now the question is, how did you, how this formula that you are using now,
Yes.
what is the basis for coming to that? How do you exercise that power
Yes.
to come to this?
That formula, your lordship, is as per the electricity supply code that was framed by the AERC, Assam Electricity Regulatory Commission.
Have you got a copy for him? Oh, for him, he has to go and do his own
My-
midnight, huh?
My learned friend was earlier, he was appearing for the APDC, so I assume.
Oh, so he knows.
Yes.
No, but then you've got a copy.
I gave it to you last time, this copy.
The relevant portal.
5.8.4.6,
5 point,
bottom of the page.
8.4.4, yes.
My friend has a copy. Lordship, I am referring to page number 1222. Before that, your lordship, take this one. There's a small amendment to this as well. So because to confirm with the amendment to earlier, this section 126(6), it provided that the calculation has to be for 6 months and not 2 times, 1.5 times. So this is,
Okay.
so this was changed in tune with the amendments in the Electricity Act. So 5.8.4.4, your lordship. At the
Yes.
bottom of the page.
Yes.
When unmetered use of electricity, theft of electricity. This is framed by the AERC under section 50 of the Electricity Act. When a consumer indulges in theft of electricity, the officer authorized in this behalf by the government of Assam may, without prejudice to its other rights, assess the quantum of electricity loss on the basis of assessed consumption of detected category as per table under 6.2.1.1 and the connected load for a period of, this has to be read as 12 months prior to the date of detection and will be billed at a rate of 2 times of the existing tariff. And the table your lordship will find on the next page at page 1225.
Yes.
Serial number 12, your lordship, on the table at clause 6.2.1.1.
Yes.
Serial number 12, that is the category of the consumer, the petitioner, tea, coffee, rubber and rubber. So that's 200 units per month. So 620 into 200 into 12. And so that is how we arrived at that calculation. Because your lordship, if we take his figure, because he was using a meter which was tampered, your lordship. And a tampered meter cannot ever show the actual consumption of electricity.
Correct.
So if we double that, your lordship, even then we cannot make good our loss.
Then you might make good, might not.
Might not make good.
They ought to be vigilant. Conduct.
No, on the other hand, you also should keep your hands to yourself. We do not know whether
That
it
is
was
why
their
the-
fault
that is
or.
why the legislature has said 12 months preceding the date of inspection.
So we'll see that part, no? I think there are some judgments where,
Yes,
On which issue?
with regard
On
to the usage of this,
Yeah.
this
There are some
formula.
I have those judgments.
This
What?
is,
One is Calcutta High Court, one Kerala High Court.
no, not only, I think Justice Gujar Barwa has applied this formula in a number of cases.
Yes, there was one judgment rendered by justice.
I think Justice Gujar Barwa has applied these judgments in a
There,
number
in
of
fact, in
cases.
that matter, I was appearing. What had happened by using this formula, the actual loss that the consumer had caused was so high that even after using this formula, the figure that we were arriving at was still in the negative. We still could not make good our loss, even after using this figure. So somebody in the APDC, your lordship, decided that instead of using this formula, There's another formula for flow meters, Your Lordship. He used the other formula. So that was the issue in that matter.
No, he has passed various judgments, I think, whereby penalty is to be paid as per some formula.
Yes, there is one judgment like they call it, it's SM Siemens versus APDCL. I remember the name of the matter. That was passed by Justice Vijay Verma.
This is a 2004 regulation,
Yes, sir.
correct?
2004 amended in 7.
Huh?
2004 amended in 7.
And then in 8th May.
Yes, 8 May 2007.
And the Electricity Act came into existence when?
2003.
2003.
126.6 was in nature, 15/6/2005.
So 126.6.
Yeah.
Now the issue is whether 126.6 or the code or these regulations would prevail. Or can we read it together?
Your Lordship, because otherwise, from my reading, the code and the code as it stands and the act, Your Lordship, are not in conflict with each other. The purpose.
Let us see. Okay.
Yes, Your Lordship.
Let us see. It says here, the assessment under this section shall be made at a rate twice. Okay. It only talks of the tariff.
Yes.
Outwardly talks of the tariff. So they're using the tariff.
Tariff. I have the tariff code also.
The tariff, they're using the tariff. Now, once they use the tariff, what is wrong with the formula used? Where is the bar on the formula?
Calcutta High Court and Kerala High Court had the occasion to interpret
Okay,
126.6.
okay.
And Lordship, there are judgments on that. There are 13, 14 of this judgment.
I have got this code already, I think. I have got only code is here. You can give this back to him, huh? I've got the code already. To this judgment, okay. Give it to Mr. Pathak.
I think he has it. Calcutta, I don't have.
Yes. Tara?
But I marked.
No, Tara, what? You don't want him to know.
No, I have got no problem. 15, 16. I have marked those back.
Citation.
Yes, what does it say?
Lordship, para 15, 16.
Yes. What does it say?
Lordship, that was the only copy I had.
It says here, we therefore set aside the order impute and direct the respondent authority to reassess it at the rate equal to twice the tariff applicable for domestic purpose. Let's touch. So how does it help you?
So they have already billed me for the last 12 months. Let them take the double of that.
That amount that has been billed, that is tariff into units. That amount that has been billed to him, 42 lakhs or that is tariff into units.
Ah.
So he is saying that he should be billed
double that amount that he
Ah,
is paying.
correct, correct.
But that amount does not reflect the actual consumption of electricity.
Oh.
Because even this judgment says it has to be twice that tariff.
Because the
Tariff is 6.75.
You have to take the load.
No, the tariff is 6.75. So it has to be 6.75 into 2
Ah.
into the number of units that he has consumed. And since the meter is tampered with, therefore
So the full load will have to be taken into account. Of course, keeping in view the peak season only.
yes.
my case is that since the date from which the malpractice has not taken place, so last 12 months, whatever I have paid for the last 12 months, they will take double of that. That is 126.60.
It does not say that.
The possible view.
It's
But then, so basically the last 12 months, you're not taking into account the meter reading at all.
because that would not, according to us or according to the, because that
That would
cannot
not show the correct
actual
reading.
consumption.
Because that cannot be ad infinitum. They'll go back 12 months.
No,
They cannot
no,
go-
no,
How
th- no,
far
no,
they can-
they're going 12 months.
12 months.
They're going only 12 months.
12 months.
You might have been they're stealing electricity for the last 10 years or so. But then they're stuck with that to 1 year.
Yes,
Or you might have been stealing it for only 2 days.
yes.
How does it matter?
So that is why if they can detect the date from which it is.
It cannot be detected. That's why the
So therefore 12 months, legislature has given a reasonable period.
12 months.
12
So
months.
then
Yes.
Then
So
12
that's what
months.
I'm saying. That's asked for 12 months.
We have done,
correct. But then now, how do they calculate the amount of electricity that you have used? They are calculating it because the meter is not going to give a correct reading.
Yes.
So they are calculating by assuming that you're using the full load. The full load. By
Wow.
calculating your appliances, the amount of electricity needed to run those appliances.
126.6 says
and
double
the-
the amount.
Huh?
126.6 says double the amount.
No, double the tariff.
double the tariff,
Not the electricity connection, not the electricity use.
double the tariff.
Tariff. Supposing they are asking that, supposing they say that diesel 100 rupees, and supposing your car is not showing the correct meeting, so they will assume that you are using full tanky every month for 12 months, and since the market price of diesel is 100 rupees, they'll say no, now you have got to pay 200 as fine. As
That will
so
be little
that will
arbitrary.
be, huh?
That will be little arbitrary.
I don't know where the arbitrary is.
I mean, exorbitant. So, Lordship, let me look into the formula which my learned friend has given, because that was not there in the affidavit. So I could not understand
That's
it
ours.
properly.
Stand was there.
I could not understand it properly. Now my learned friend has explained it. So Lordship will grant me some time, I'll look into it.
Let him look into it.
Right.
His money after all.
Yes. Very well.
But I think there is their judgment.
I just,
The-
Justice Bhujabara's judgment, I have a copy, but the issue, though it was the same clause, the issue was,
No, where he has given, where he has calculated the amount of penalty to be paid.
I'll have a look.
There are there.
Very well.
I think he has used the same formula.
I'll have,
So if he has used the same formula, then I'll have to follow that.
very well,
That's what I'm saying.
very well.
I think there is. When do you want?
After 2
Okay, right. Mr. KP Pathak, Learned Counsel for the APDCL, has submitted a letter dated 29/7/2024 issued by the CGM bracket COM and E bracket close APDCL, showing the manner in which, showing the formula by which the penalty is to be paid in case of alleged theft of electricity. Mr. P. Bhaumik, learned counsel for the petitioner. Prays for time to peruse the same. Praise allowed. This is the matter on.
My learned friend is otherwise not filed a rejoinder. If he wishes to, then he can file it in the.
Praise allowed. This is the matter on. 20th. 20th August. Comma, by which time the petitioner should. The petition. No, but 20 is enough time. It's a small issue. By which time the petitioner's counsel should file his affidavit in reply, if required. You see, the issue is very simple. It's only whether whether they can do it. Now, where is the, I don't know. There doesn't seem to be any clash between the act and the code. Doesn't appear to be.
Otherwise, if this formula was not there, then the assessing officer, at his whims and fancies, he could have assessed the consumption.
Correct.
Because it refers to a best judgment assessment. It gives him that power. But to circumscribe that power, this formula is there. So there is some objectivity to his assessment.
In income tax, best judgment assessment is last 3 years average.
Income tax.
Yeah. Last 3 years average.
But electricity, though, how do you know?
But there shouldn't be much variation. I don't know, let me check.
I don't. But where is the bar for them to make this formula?
Once they explained it to me a lot, I mean, in these words, then it clicked, okay, this is how it's happening. Otherwise, your lordship, kilowatt and these terms sound so foreign, your lordship. So once the meter is tampered with and an ampere cannot be recorded, so the entire consumption that the meter was showing prior to detection of that tampering, everything is cast, your lordship, it's cast in doubt.
There are judgments, bro. I think it's past 2-3 judgments.
I'll look into it.
I'll go through.
I think Mr. S.K. Kejriwal might know.
Oh, yeah.
I'll have a word with him.
Ask him. I think he knows. I put this in the